Thanks everyone for joining us this afternoon. We set this up with the intent to make this a short opportunity, so it's a half hour of your time, and we appreciate you logging in and being with us. Our goal today is to provide you with kind of important information about the pending deadlines in Ohio, as well as developments here that are particular interest to retailers, and then provide you with as well a little bit of a regional update as it relates to what's going on of interest to the retail community. Andrew DeBoard is joining me, my co-presenter today. Andrew and I are part of a 20-lawyer real property tax and economic development incentives practice here at Voorhees, which we believe, if it's not the largest, is certainly one of the largest law firm-based practices in the country. We are representing clients and providing service to them currently in all 50 states and Puerto Rico, and have the capacity to advise on Canada as well. So we're going to be focused today kind of on the Midwest and specifically on Ohio, but certainly we'll open it up for your ability to email us later with questions, and I would say feel free to expand those questions beyond just the states and jurisdictions we're talking about if those are of interest to you. Again, as part of keeping this short, there is the box on your screen there with the questions. Feel free, if you have them, to type those in. If we run out of time in trying to keep this to a half hour, we will reply back to you separately. So if we run out of time, please still put your questions in. And as I said, you have opportunity to email both Andrew and I as well. The final thing to kind of talk about as it relates to our practice, just so you're all aware, probably more than half, well over half of the work we do in this area is done on a success fee basis, meaning that it doesn't cost for us to review and monitor assessments. We really get paid once savings are generated, and that allows us to offer a complimentary review of your assessments. So if you are looking at something, you're not sure, you've got some properties you'd like to get an opinion on, feel free again to reach out to us. We would be happy to do that, and there's no charge associated with that initial review and advice. All right, turning to what would be the second slide, and looking at Ohio. We're coming down to the end in Ohio. The filing deadline here in Ohio is April 1st. And what you see on this screen are those counties. Ohio has a 6-year reappraisal cycle. Those counties that reappraised for 2018 are at the top. And our counties do a mid-cycle update where they go out and perform a statistical analysis and come up with percentage updates. And those are called the triennial updates. And you see those counties listed there as well. The one thing to understand, though, is that you can file in any county at any time. So while these counties are presented here, they're the ones where valuation changes were likely to have occurred for the bills that you just saw. The other counties in the state can be filed in if you didn't last year, and there's an opportunity there. So don't limit your review to just these, but understand these are where the changes likely occurred. And it is a heavily large northern Ohio county list. This is the second largest list of reappraisal counties on the 6-year cycle for 2018. And you see that it has Cuyahoga, Lake and Lorain, Stark, Lucas. It is all of the counties kind of up along the lake shore in Ohio were up for reappraisal this year, as well as some counties down south like Warren or out east in Belmont and those types of counties. But certainly we can look anywhere, but those were the big ones. From the standpoint of reappraisal, and I think this was true with last year's reappraisal as well as this year's reappraisal, if I had to categorize it, I would categorize it as sporadic and not systematic. And so the valuation results that we're seeing across the counties We do not see them highlighting a particular property class or an area where they have gone out and said, boy, we think all X types of properties we're going to take a big move on, and it's this category of owner or tenant who really needs to be looking because everybody else seemed to do okay. That's not what our experience has been and what we have seen with the reappraisals. It has been somewhat difficult to justify the differences that we see. And there's a lot of potential reasons for that. I think the most important of which is the limitations on the information that the auditors are seeing. So kind of outside the scope of what we're talking about today, but a lot of properties in Ohio are transferring in non-traditional ways, transferring through entity sales primarily or other methods that do not result in recorded sale prices being obtained in the county auditor's office. Without that information, they're really then limited in what their in-house information provides them. And my opinion, at least, is that is part of the reason we see the sporadic nature of the numbers and the changes. That means if you have properties in those counties, I can't tell you, boy, retailers did great in Cuyahoga County. If you got properties in Cuyahoga, you're fine because they really didn't make a significant move. We've seen it all across the board, why that regular review as the valuation changes are necessary. The other thing to be aware of on this cycle, and we didn't list all of the counties here just because of the amount of space it would take, is that the timing of when you file, there's some bit to that of when does it make sense? When is the cost benefit there to file? And that's often tied to where you are in the valuation cycle. So if you're interested, and again, it isn't up here at the moment, but if you're interested, email us, we'll send it to you. We have a chart and a color-coded map that shows all of the counties, shows, again, in a whichever is best for you, in a map format, color-coded. If you're visual or you like the spreadsheet version, we can send that out to you, and you can have it for Ohio to look and see when the changes are coming. Also helps from a standpoint of doing your budgets to know when the changes are coming up and when you might expect to see that something is going to happen. From a filing standpoint, if you've reviewed it, you've identified there's something there that needs to be done. In Ohio, March 31st is the statutory deadline. That falls on a Sunday this year, so that date's moved out to April 1st. And again, if you're active in a lot of states, one of the things Ohio does right comparatively is that our appeal deadline is the same for every county. It's not running around every appraisal district trying to figure out when the appeal deadline is. It is March 31st, April 1st this year. The other thing to be aware of, this is a few years old on a change now, but you can use certified mailing. So the Ohio statute says it must be received by April 1st. Certified mail is considered receipt. So if you down at the end, you're trying to get a complaint done, you can certify mail it in. If you regular mail it and it's not received by April 1st, it will not be a jurisdictionally valid complaint. The other thing that we see a lot of discussion on is, particularly in the retail area, is this idea of who can file on behalf of the property owner. If you are leasing the property, can I file as a tenant? And in summary, generally speaking, tenants do not have independent standing to file a complaint. Now, the Beaver Creek case that's listed here came out last year, dealt with a situation where the tenant was authorized to file on behalf of the owner and listed both the owner's name and the tenant's name on the complaint. So there's some saving case law out there, but it's certainly not something that's recommended. Jumping ahead a little bit, they're out of order, I think, on the slide here, and I apologize for that. In a situation where you are a tenant and you would like to challenge the valuation of your property and your lease allows you to do so, one consideration is whether you are also own property in the county. So if you own some properties, lease some properties, we have a number of retail clients that are in that scenario. You can file in Ohio as an owner of property in the county. If you're going to do that, give one of us a call, making sure you complete the form appropriately, disclose what you're doing appropriately, allows you to be a little more transparent with the fact that this is who's filing the complaint without running into jurisdictional pitfalls. So be aware that you can do that. I would say talk to us first before you do to make sure that it's done appropriately. And then the who may represent an owner at the hearing, and probably should say who can file the complaint and who can represent the owner at the hearing, are two separate questions. Ohio statutes allow for a broad listing of who may file the complaint. And the courts have generally, for example, allowed an employee of the owner to file the complaint. And that employee is able to do that, but the employee is going to run into a problem down the road. Filing the complaint and representing the owner at the hearing are two different things. And some boards will not make an issue of it, or some school board attorneys will not make an issue out of it. Some will, and you may be able to file the complaint on your own, but when you get to a hearing and start the advocacy process, now it turns over into the practice of law. So there's another, we could do a half hour at least just on that question. If you're in-house and you're thinking about filing a complaint, again, give us a call. We'll kind of explain to you kind of what you can do and what you can't, and not run into trouble with the Ohio Supreme Court. The last two slides on the Ohio portion before we start talking a little more regionally are the case law developments. The first one is the favorable decisions. The Ohio Supreme Court generally over the last year and a half or so has been very favorable to retailers. And you'll see these cases listed here. The first one was really the Terraza 8 decision. The legislature changed Ohio's valuation statute in 2012 and 2013 to specify the interest to be taxed. Our Board of Tax Appeals decided, frankly, to ignore that change in law for years until the Supreme Court told them differently. They finally told them differently in Terraza. It was a leased fee sale. The court said where there was appraisal evidence to show that the leased fee interest was not equal to the fee simple interest, the sale could be disregarded and the appraisal looked to for valuation purposes. So that's really Terraza's the lead case there. Bronx Park followed that up and said, yep, remand it back. BTA has to consider the appraisal. On a Walgreens case, Terraza was Lifetime Fitness. The Westerville case is here because it's significant in that it's not just looking at the underlying lease rate. The Westerville decision says that an old case in Ohio, the Ratner decision, which dealt with the creditworthiness of the tenant, financing terms, other things beyond just lease rate, was also good law and kind of re-brought up Ratner again. So that Westerville case, significant in that regard, and there have been a long line of remands back from the Supreme Court on that issue. The other great one for retailers was actually taken up by State Farm. State Farm is a sale leaseback case, and believe it or not, Ohio was taking sale leasebacks that value is reflective of the value of the property. That is, we would be at national conferences and people would just kind of scratch their head over how somebody could think that to be the case. That case finally got in front of the Ohio Supreme Court. Ohio Supreme Court said, yep, sale leasebacks are presumptively invalid. And that's a difference from these other cases where the sale in the Terraza line of cases is good unless the property owner shows differently. On a sale leaseback, the property owner just needs to know it's a sale leaseback, then the sale's presumptively invalid, and now you're just into a valuation fight from there. Unfortunately, while the Supreme Court has been good to retailers, The Board of Tax Appeals and our appellate districts have not. And this is more recent in development than the previous cases. So Ohio changed, used to be, we had a right of direct appeal to the Supreme Court. And we thought the BTA got it wrong. We got to get in front of the Supreme Court. They had statewide, of course, jurisdiction. They would decide these cases. That is no longer the case for real property tax. Real property tax cases have to go from the Board of Tax Appeals to the appellate districts. And generally, I would say we've tracked every appeal from the BTA to the appellate districts so far that have resulted in a decision. Not one of those decisions that I'm aware of has the appellate district overturned the Board of Tax Appeals. They're not knowledgeable about tax issues. They're seeing it for the first time. They're really just deferring back to the Board of Tax Appeals, which if you compare it to the Supreme Court, track record over the last 2 or 3 years, the Board of Tax Appeals was routinely overturned in matters sent back. We now have appellate districts rubber stamping it and no right of direct appeal to the Supreme Court. So that is a challenge in Ohio, and it delays the amount of time to get issues resolved. Ohio's decisions of concern to retailers have really focused on highest and best use. So we're going to hear Andrew talking in just a second about dark store theory and what's happening nationally on some of those things. Ohio really hasn't kind of thrown that term out yet, but we've done it through highest and best use. So the first cases you see there are McDonald's cases. And what happened in those cases, the appraiser for the school board narrowed the highest and best use for the property to national fast food restaurants. Well, you know, McDonald's is in there. Wendy's isn't coming in behind them. Burger King isn't coming in behind them. By limiting it to national fast foods, really the comparable set now becomes all leased fee sales. Often leased fee sales that are subsequent later down the line from a sale leaseback with really high lease rates attached to them and therefore high values, and takes into account in many cases in the fast food area a percent of sales approach to get to the lease rate that has really nothing to do with the underlying real estate, but much more to do with the business being conducted. So by allowing this narrowed highest and best use, if you have two franchises, two fast food right next to each other, one is vacant and available for purchase, you can absolutely disregard that option, not use it, not have to rely upon it. The store next door, the location next door could sell, and you could they could ignore it for purposes of setting value. So that is very concerning. The other one is, again, another highest and best use issue, and that's kind of a limit. This one just came out at the end of February, the Lowe's case. Highest and best use there is limited to the current owner-occupant. So it's a 16-year-old owner-occupied Lowe's in Cuyahoga County, Ohio, that by limiting those comparables or that use to the current user, the board says, well, it's not special purpose. It is special purpose, but we're not going to do a cost approach. It's just kind of odd. And they're going down this road now, contrary, I believe, to some of the Supreme Court decisions. But case is going to have to be appealed, and then we're going to have to wait to see if it goes to the Supreme Court. Frankly, I think what we'll likely see here is at least some discussion of some legislative changes in Ohio. As you see these highest and best use issues, and as we kind of transition and hand it off to Andrew, this dark store theory, you don't hear about highest and best use or dark store theory on an office building. You don't hear about it on a distribution center. We're not talking about it in that regard. It is a retailer-focused assault on value, and I think we'll see hopefully some action legislatively to try to bring back some uniformity in Ohio so that retailers aren't being singled out in these types of cases compared to other property types. So with that, I'm going to turn it over to Andrew to go through the final slides.
Thanks, Nicholas. As Nicholas mentioned, we haven't seen dark store theory being proposed through legislation in Ohio thus far, but we hear it all the time in hearings from our opposition. And it's you see this word originally coined in a lot of the Midwestern states, Minnesota, Wisconsin, Michigan, Indiana, a lot of Rust Belt areas. And it kind of originated there in local jurisdictions and now has gone national. And I don't know if anyone saw this, but the New York Times picked up an article about it earlier this year. So it has spread nationally. So what is the dark store theory? It's really what it is. It's a propaganda term that's been coined by assessing jurisdictions and appraisers working for them to say that thriving operating big box stores are trying to be valued as if they were vacant and closed and not in operation. And in order to do so, they're presenting comparable closed, dark, vacant retail stores as comparable sales in their appraisals and in their analysis they're presenting to these assessing jurisdictions in the Midwest. Now, the opposition tries to play the big corporation versus a small community argument. These big box retailers are trying to take money away from government jurisdictions, libraries, school district, townships, whatsoever. But in reality, these most of the laws in these states say that fee simple interest needs to be valued for these properties. So the assessors, however, in those jurisdictions wanted to try to argue that most of those properties have either build-to-suit leases in place and they need to be valued as such. I want to move on to the regional update in various states around Ohio to kind of discuss this dark store theory. In Indiana, we've seen some legislation passed in 2015 that tried to pass legislation that all first-generation big box stores with an effective age of 10 years or less should be valued under the cost approach. That was kind of immediately repealed in 2016 and replaced with other legislation that made it such that you had to look at the local market. We also saw a nice case that Meyer won earlier this year where the Meyer appraiser used an income approach and a sales comparison approach that utilized both lease fee sales, market leases, and the opposition's appraiser used a cost approach. And she tried to argue that there was no obsolescence to that Meyer because it was built for Meyer, for their specifications. There's no functional obsolescence involved, and it should be valued as such. Meyer won that case, so that was a good decision for them, and it was good news throughout Indiana for all retailers. In Kentucky, we've seen similar results for some retailers. However, Walgreens did lose a case recently at the circuit court level for a leased location in the Lexington area. There was a long-term build-to-suit lease in place for that location as well. The opposition used sales of leased Walgreens to try to support the fact that their valuation should be high and should be based on this build-to-suit lease. If it was exposed to the open market, it would sell the lease in place. Walgreens unfortunately lost that case again at the circuit court level. The Kentucky Supreme Court declined to hear it, and their high valuation based on that build-to-suit lease stayed in place. In Michigan, we've seen a litany of retailers come through and try to push cases on through the Michigan Tax Tribunal and to the appellate court and Supreme Court level. I want to mention a Menards case that dealt with this dark store issue. They presented a lot of dark store comparable sales in their appraisal, and again, the Michigan Tax Tribunal sided with them. Unfortunately, the appeals court did not. The Supreme Court of Michigan declined to hear the case, which was one of the first times these cases have been overturned dealing with the dark store theory. In Michigan, we've seen legislation try to be passed through as well. In 2016, there was an attempt. It was passed in the House. It was denied in the Senate. There's been new legislation introduced in 2017 and now in 2019. So there's certainly an effort there in Michigan as well to pass some of this legislation through. I'm going to move on to some of the deadlines for surrounding states to Ohio from the appeal standpoint. As Nicholas mentioned, we're facing a March 31st deadline in Ohio. This year it's April 1st due to the fact that March 31st falls on a weekend. Indiana, there's a May 10th deadline. However, you'll see a lot of county jurisdictions issuing assessment notices after that, and you'll have 45 days to contest that notice with your local assessor. The next levels after that would be the county board, and then you get further down to the Indiana Board of Tax Review, and then the Indiana Tax Court. Meyer won that decision at the Indiana Tax Court. Kentucky, they also have an upcoming deadline in May. You're able to discuss your valuation with through a conference with your local PBA at the county level. Third Monday in May is the appeal deadline if a result cannot be obtained at the conference level. And then from there, you're talking about the local Board of Assessment Appeals, then the Kentucky Claims Commission, and then the case progresses further, you're talking about an appeal to the county circuit court level. So again, various levels of appeals in Kentucky as well. In Michigan, there's two deadlines you need to be aware of. In February and March, you're able to discuss your valuation with the township assessor. The May 31st deadlines with the Michigan Tax Tribunal. We often see some results at the local level, but oftentimes an appeal is necessary to the tax tribunal by May 31st. Pennsylvania is a very strange state. You have various deadlines in various jurisdictions, both on the western part of the state and the eastern part of the state. Allegheny County, where Pittsburgh is, has a March 31st deadline, which is coming up here very soon. You won't see deadlines approaching in most of the eastern counties near Philadelphia and in the central part of the state until August. And you'll see some various deadlines in August and September for those counties. West Virginia just had a local appeal deadline to the Board of Equalization at the county level there. That's since passed, and those appeals will be certified to the Board of Assessment Appeals in October if they can't be resolved between now and that time frame. So that's it. Are there any questions regarding dark store? Go ahead, sorry.
No, I was just going to say thanks, Andrew. I think we're afraid that this might happen. We're going to get to the 30 minutes in. So the last slide's really asking if you have questions. I think the one thing I'll respond to quickly is that if there is something you want us to review, what you would need to do is email us a brief property description and parcel numbers if you got them, and for the most part that will get us started. So I can answer that one right now, and we will respond to the other questions offline in interest of your time. Again, you see our contact information there. Feel free to call us or email us. I'm looking at the corner of the screen and it says 12:30, so we are wrapping up. Again, we want to be respectful of your time. We appreciate you participating. This will be available online, so if there are other folks in your organization who you say, boy, you should have seen this or heard this, you can send it along to them, and that will be out or posted at some time shortly. Again, thank you all. We appreciate your involvement, and enjoy the rest of your day.